William Shealy, person that's going to be building on this residence.
Sean Brickmore, homeowner on Brick Road.
I'm just here to watch.
Who are you?
I'm just here to watch. I don't feel comfortable giving my name.
Okay, I know.
Access and avoid potential litigation. Thank you.
Would anybody else like to speak? Our mysterious guest?
No, I'm good.
What you said, what you're claiming, where's that written?
Revised Code of Washington. These are the rules that we all abide by. And you were sent this, Sean. Mark Story and I sent you this very piece of information.
So, Mr. Thompson, you're saying that we don't have to follow the code?
No, I'm not saying that at all.
You just said that.
Did I say you don't have to follow code?
You said that yeah, by definition.
So what I'm saying is that there's always an impact.
Variance depends on other properties
That,
and water rights.
no, I disagree.
Well, I disagree with you.
Right, so the decision is up to the board, not you. Not you.
That's also state law.
Sorry,
And
sir.
again, if you're not legal experts and you're not geologists, why am I even here? Why are you guys here? If you don't know anything about the issue, how can you make these determinations, these conclusions?
Mr. Crickmore, we're here to decide on the Viewshed variance.
The Viewshed variance depends on its effect on the surrounding neighbors.
It's amazing what you guys do.
I think what you're doing is absolutely marvelous.
One, two, three, four.
What's going on?
You don't. There's no expectation of privacy in public.
Illegal in Washington to record to
It's not though. Yeah, it's the First Amendment. Aren't you guys recording us though? That's kind of a double standard. My right to do this is the First Amendment. Freedom of speech, religion, press, petition, and assemble. What's your right to that? I shouldn't be. Like, you don't want to be recorded. Have a good night. You live in a park. It's paid for by tax dollars. I'm not. It's the First Amendment. That's why I'm doing it. Okay, no, it's not. It matters. It's just about more.
Ken? Yes. You hear me?
Yeah, we can.
So do we have one? that?
The viewshed requirements, I keep seeing, I mean, it says that in here, but I don't know what that means.
Basically, don't build on the highest point of your property.
So,
It'll be enough.
No, we're looking at it right. The viewshed is that you can't build within 1,500 feet of another residence.
Of the actual residence,
Residence to residence,
okay.
unless it's an existing parcel that was there before 2007 and has not been built upon. Still nobody.
Still two.
I think Ryan is not going to join us because he thinks we've got a.
I've been texting with Ryan, he said if we needed him to, he could stop and try to jump on, but he said just now he'll try to pull off and log on, being Rick hasn't. Oh, yeah.
Sorry, Brian, we're only at two right now.
Still floors me that chunk of ground is zoned as agricultural, cause you ain't gonna grow nothing on that hillside. Sure you might be able to grow some grass.
Most of the county is agricultural.
Yeah.
Rick Finch is here. Rick, can you hear us?
Yeah, I can. Sorry about that. I must have an old link. Can you guys hear me?
Yes, we can.
Okay, thank you.
Yeah.
Yeah, we're up for him.
Okay, so it's 7:06 on September 26th for the Board of Adjustment meeting for the public hearing for the variance. Did I say who's here?
Let's have some intros.
I am Michael Cochran. I am the chair this evening.
Rick Finch, member Board of Adjustment.
Brian Davies, Board of Adjustment.
Alan Thompson, County Planner.
Grace DiBiase, Assistant Planner.
We have a microphone. If the people out there could introduce themselves, please.
William Shealy, person that's gonna be building on this residence.
Sean Brickmore, homeowner on Brick Road.
I'm just here to watch.
Who are you?
I'm just here to watch. I don't feel comfortable giving my name.
Okay, I know.
Okay. Applicant Blaze and McKaylee, how do you say that? Shealy. The request is a variance from the agriculture district viewshed requirement. Location, the site address is 1071 Brayton Road, Pullman, Washington 99163. It's in the northwest quarter of section 25, township 15 north. Range 44 East, Willamette Meridian, Whitman County, Washington. The findings of fact. On August 30th, 2024, Place and McKaylee Sheely requested a variance from the Agriculture District Viewshed requirement. See Exhibit 1, application. Number 2, the site address is 1071 Brayton Road, Pullman, Washington 99163, the northwest quarter of Section 25, Township 15 North, Range 44 East, Willamette Meridian, Whitman County, Washington. See Exhibit 2, vicinity map, and Exhibit 3, an aerial map. Number 3, Section 19.06.020A5, in the case of a landowner seeking a variance from the 1,500-foot viewshed restriction of Section 19.10.060. The parcel under consideration, A, was in existence at the time of the passage of this ordinance, and B, has not been subdivided since the passage of this ordinance. And C, no prior variance has been granted for an existing RHC for that particular viewshed. See Exhibit 4, Section 19.06.020A5. Number 4, the applicant proposes to construct 2 new residences on a 6-acre parcel that has been in existence prior to January 1st, 2007. Due to the size and location of the parcel, the applicant is unable to be outside of the viewshed of 6 neighboring residences. A variance is required from the Board of Adjustment to construct a new residence within a viewshed. See Exhibit 5, site plan. Number 5, the parcel is located approximately 2.5 miles southeast of the town of Albion and is surrounded by farmland on all sides. There are 6 residences within 1,500 feet of the proposed residence. 901 Brayton Road, 852 Brayton Road, 801 Brayton Road, 781 Brayton Road, 652 Armstrong Road, and 1001 Armstrong Road. 3 of these homeowners have contacted the county expressing concerns about potential impacts to their wells. See Exhibit 6A, B, and C. 3 letters of concern. Is that still just the 3 or did?
Yes.
Number 6, a notice of a hearing with the Board of Adjustment was advertised in the Whitman County Gazette on September 12th, 2024, and no comments regarding the proposed zoning action were received by 5 p.m. on September 26th, 2024. See Exhibit 7, Board of Adjustment hearing notice to the Gazette. Have there still been no comments received?
Not from the notice, no.
Number 7, all landowners within 1,500 feet of the site were notified by mail of the variance application and Board of Adjustment hearing. The written comment period for the variance ends at 5 p.m. on September 26, 2024. 3 comments have been received as noted in finding number 5. See Exhibit 8, affidavit of mailing, and Exhibit 9, notice of Board of Adjustment public hearing. Number 8, at the time of this hearing, only the 3 aforementioned comments in finding number 5 have been received by the Planning Division concerning this application. Number 9, a response to 2 of the letters received by the Planning Office concerning water usage was crafted by the County Director of Public Works, Mark Story. See Exhibit 10, response letter by Mark Story. Number 10, the granting of a variance from the Agriculture District viewshed requirement will not constitute a grant of special privilege because the code allows for a variance to be granted per section section 19.06.020A5. In the case of a landowner seeking a variance from a 1,500-foot view shed restriction on section 19.10.060, the parcel under consideration A was in existence at the time of the passage of this ordinance, and B has not been subdivided since the passage of this ordinance, and C, no prior variance has been granted from existing RHC for the particular view shed. See Exhibit 4, Section 19.06.020A5.
So, Mr. Chair, we need to enter a couple more comments from the adjacent landowners. There were 2 comments that I sent to you just recently, one on September 24th, one today. So both of those need to be entered into the record. The first one could be exhibit number 11, and the second one exhibit number 12. Both comments are from Sean and Emily Creedmoor, and a response from Mark Story, Director of Public Works.
Okay.
So we need to make a motion to enter those into the record.
Okay, I will entertain a motion to add those 2 exhibits into the finding of fact.
Rick Finch, move to enter the additional comments and responses from Mark Story as exhibits number, was that 12 and 13, Alan, or 11?
11 and 12.
11 and 12.
I will second that motion.
So as it's been moved and seconded, we need to vote. Rick Finch,
Yes.
Brad Davies,
Yes.
Mike Cochran votes yes as well. Motion passes.
So before we move on from the findings of fact, this is Rick Finch again. A few clarifications, and I don't know, I need staff's opinion if this needs to be in the findings of fact, but given the comments and responses from Mr. Story, it seems fairly clear that the county's position is that the Board of Adjustment, in this case, doesn't have really any standing in the issue of the water. We certainly have no expertise in the geology and hydrology involved. So, in spite of the comments and the concerns about water, it seems to me that this hearing is really strictly limited to the viewshed. So, I don't know if we need to add anything about that, Alan, or if it just needs to be in the record, but I'd like to know if I'm reading this correctly.
Yeah, yes, I agree. There are people in the audience that may want to speak, and we should allow them to speak. And then afterwards, we can discuss how to move forward.
You're welcome.
Sean, would you like to speak?
Yes.
Make sure you got the mic there. And introduce yourself, please.
My name is Sean Brickmore. I'm the homeowner at 801 Reagan Road. As a homeowner within 1,500 feet of 1071 Reagan Road, I'm concerned about the cost and hardship neighboring properties may face due to well interference from this new resident development. My home has irrigation water rights, up to 32 acres. And I worry that the well could interfere with our permitted use, especially since our irrigation well already had to be deepened by 120 feet to maintain sufficient irrigation use. Within County's Code of Ordinances and the Supreme Court's first decision requires the county to protect existing water resources both physically and legally. I respectfully urge the Commission to carefully consider this matter and deny the variance to prevent harm to local water access and avoid potential litigation. Thank you.
Would anybody else like to speak? Our mysterious guest?
No, I'm good.
Will this be the only time to speak, or?
Well, yeah, go ahead, you need to say something, Blaze, go, yeah.
Oh, my report's coming in.
Oh, we have someone on the line?
Yeah, we have two.
Yeah, so on my report, I'm an adjacent land owner. I also submitted a letter of concern regarding this. After receiving the response from Mark's story, I think I understand how the situation of where the water actually comes from and whether it's in the deep partition or the shallow. I can see that there's uncertainty there. So, I don't personally have any reason to continue to protest this. So I'm okay with this moving forward. I'm sorry about that, Sean, but that's the way I feel based upon the response.
And I agree with Rick in the fact that we're not, like you said, we're not hydrologists, we're not geologists, we don't know. That's what the county planner and whatnot are for. Our job is basically just to make sure the I's are dotted and the T's are crossed, as far as I can tell.
Is there anybody else online that wishes to speak? Okay, Blaze.
Yeah, Blaze Shealy. I just wanted to add my comments as well, that I feel like this is really relegated to the Viewshed in and of itself. As far as I understand, because I've tried to dot my I's and cross my T's throughout this process, there doesn't seem to be any restriction when it comes to the water situation and well drilling. If any, I do want to extend though to any adjacent landowners, if they want to have a conversation, like I'm more than open to that as well. But once again, just doubling down, I do think that this is really relegated to just the Viewshed.
Well, I'm going to add to this conversation. As the county planner, we have reviewed, the original claim about the Hearst decision would have been legitimate if the Hearst decision was still the same as what it was back in 2008. It isn't. Since then, the legislature has changed the code to correct that possibility that the landowners, the individual landowners, are responsible for proving that they have potable water there. So it's very clear the RCWs do not have any lack of clarity to it. This is not something that Whitman County has any responsibility for. It still remains in the hands of the Department of Ecology as to water usage, especially with exempt wells. So it's a non-issue. Sorry for that, for the people next door, close by, but this is not something that we can make a determination on. That is up to the board, that is up to ecology. And what the RCW requires is a positive well report, which Blaze, you'll need to give us at some point here real soon. I know you've drilled the well, so there should be a well report, and that responsibility is in the hands of the well driller. So when water is proved potable and that report is in our hands, that question goes away. And this truly is about the Viewshed. And the Viewshed originally was crafted to take into consideration agricultural landowners and a potential impact from the residents next to an ag field. That was why it was crafted. I was there when that happened, and that was the intention. Not to give residences a voice to object to another residence next to a residence. That was not the intention. However, we decided, the planning commission decided, that we need to notify all landowners, regardless of whether they're agricultural or not. That's why the houses, any residential close by is involved with notification of it. So that's where we stand, and I would recommend to the board that you just move ahead. The water should not be something that you have any ability to have any influence over.
I would like to reply to that.
Go ahead.
What you said, what you're planning, where's that written?
Revised Code of Washington. These are the rules that we all abide by. And you were sent this, Sean. Mark Story and I sent you this very piece of information about the RCWs. And also that letter from the Hearst decision and hailed as the Hearst fix from Schroeder Law Offices. Those were sent to you. And did you receive them?
From Mark Story?
Or me? I think it was Mark Story that sent you.
Right.
So this explains what happened after the Hearst decision.
Oh no, I did not receive that letter, no.
Yeah. Well, I have on my computer that it was sent to you.
Okay.
So that means the law of Washington was changed after the Hearst decision.
2016.
You know, to put responsibility of water back in the hands of the Department of Ecology.
It's a state law that the county is responsible for determining if there's physical and legal water access.
I suggest that you read the RCW.
I read the Supreme Court decision.
Oh, cool.
This is your interpretation.
No.
Yes, it is.
Okay, so let me just amend my perceived interpretation by yourself. The Hearst decision happened in 2008.
No, 2016.
No.
Okay.
So
we're disagreeing here too.
all right. So what is more important is that the state legislature, the Washington State Legislature, those are the people that make the rules in this state,
Yeah, I know that.
changed that decision. Obviously, changed the RCW, and they put it back in the responsibility of work to the Department of Ecology. That is current law, today's law, which.
And they need to update their website, because that's not what it says.
Well, did you go into the RCW
I went
website?
to the website.
Which website?
It's the,
There's a specific code, website for the, RCWs, the Revised Code of Washington, which I went into 2 days ago, and I got this. And if you had been in the same website, you would have been able to get the same RCW that I'm looking at here, 1927-097. And my recommendation to the board, regardless of what we're hearing elsewhere, is that this is not your responsibility. Water is the responsibility of the Department of Ecology. End of story.
No, and also, Whitman County Code of Ordinances also says a variance will not be detrimental to the public health, safety, and welfare or the interest of the properties. So just granting of the variance depends on other properties. And water rights.
No, I disagree.
Well, I disagree with you.
Right, so the decision is up to the board, not you.
Alan, excuse me, Rick Finch here. So, I think, one of the issues is then when there's a statement of concern, even though I do believe that the county's information, legal information on our standing, that this is correct, but when it comes up to one property owner's rights versus another property owner's rights, you have a concern that this building may cause an issue with your water, but you do not have documented proof that that is, and we cannot rule against the landowner just because somebody is worried about something. And that's something that we've had precedence in many decisions over the years, but I think the argument about whether or not this is in our purview, we do not have the expertise to deal on water, and the county has legal representation, and, you know, frankly, as a member of the board, that is what I'm going to act on.
Well, then what is my recourse? If I do have to, you know, deepen my wells, who do I just have to open my checkbook and pay for it myself?
So there is a process with water law in each state, including Washington State. So and there's priorities. So there's first in line.
Which we have senior water rights.
Senior and junior water rights. So if a senior water right is impacted in any sense, then there is a recourse for that, there is a process for that, and you have to prove that you have been impacted, and that's not done locally. That's not done through the Board of Adjustment nor the county commissioners. So that is the process. If a senior water right is impacted, you have the right to pursue that with the state. And that would probably be with the Department of Ecology, because they're the ones that have the logs as to who is senior and junior. And there are no in-stream restrictions in Whitman County right now, none. So that has to go to the Department of Ecology if your water is impacted. And then you have to prove how it was impacted.
No, the county is also responsible for maintaining stream flows. That's also state law. And again, if you're not legal experts and you're not geologists, why am I even here? Why are you guys here? If you don't know anything about the issue, how can you make these determinations, these conclusions?
Mr. Creekmore, we're here to decide on the Viewshed variance.
The Viewshed variance depends on its effect on the surrounding neighbors. That's in
the ordinance on the Viewshed is very specific on whether or not we can grant it, and based on my review of all the documentation we were sent, I see no reason, I don't see a way we could deny this Viewshed legally, or this variance legally.
I disagree.
Blaze Shealy speaking again. And then I did just want to add as well, as we were talking about this being for the Viewshed, this is more specifically for that this parcel is exempt from the Viewshed. So even if there were any additional requirements for the Viewshed, those being approved by the surrounding homeowners, I think that it seems pretty clear that this parcel is exempt from the Viewshed and anything else that may entail.
I agree.
Can we see 19.06.020 section B under variances?
I don't think you have that.
That was sent out, Alan, with
1906 is the chapter in County Code about variances. And that's the responsibility of the Board of Adjustment, and it just highlights what we have to do. And essentially, it gives you the same language that you're going to be voting on here shortly. So on the 4 parts, that's
I believe it was one of the exhibits at the end of this document with the findings of that.
That's correct, and it, I believe that is what
there. I think you just scrolled past.
Mr. Creekmore is referring to that.
Yeah, it's in exhibit number 4.
Right there.
B, the granting of the variance will not be detrimental to the public health, safety, and welfare or be injurious to properties, to the other properties and improvements in the vicinity of the subject property. I think that's what he is referring to.
That is correct, yeah.
Does that apply? Is my question. Does that apply to our conversation tonight?
It always applies, but that is kind of the nature of zoning. When you do something, it potentially impacts somebody else. It always happens. If we held that to a strict, really strictly, nobody would be able to do anything.
So we don't have to follow code, is what you're saying?
Sorry,
Right.
you're gonna speak, you need to speak.
Again, you're saying we don't have to follow code. Can you speak up? So, Mr. Thompson, you're saying that we don't have to follow code?
No, I'm not saying that at all.
You just said that.
Did I say you don't have to follow code?
You said that yeah, by definition.
So what I'm saying is that there's always an impact. And then if we're going to have any kind of zoning, there's always going to be an impact, so we have to factor that in. There's always a detriment somewhere. That's the nature of zoning. So what I'm saying is, we just have to accept this, there are going to be some impacts.
It says a variance cannot be granted.
Yeah.
It says that right there.
I'm not really going to have any success with this conversation anymore, so I put it back in the hands of the Board of Adjustment to make that decision. It's not my decision, it's the Board's decision.
So I guess, that means we move on to number 11. The variance request is consistent with the Whitman County Comprehensive Plan.
First of all, you need to approve the findings.
That's,
Yeah.
so I will now entertain a motion to approve the findings of facts.
I'll move Rick Finch.
Second, Brian Davies.
Having been moved and seconded, we will move on to vote. Rick Finch,
Yes.
Brian Davies,
Brian Davies, yes.
and I, Michael Cochran, yes as well. We'll now move on to the board shall discuss the following points during the hearing with a yes or no vote. A, that because of special circumstances applicable to the subject property, including size, shape, topography, location, or surroundings, the strict application of the zoning standards is found to deprive the subject property of rights and privileges enjoyed by other properties under identical zone classifications. Rick Finch,
Yes.
Brian Davies,
Yes.
Michael Cochran, yes as well. B, that the granting of the variance will not be detrimental to the public health, safety, and welfare, or be injurious to other properties and improvements in the vicinity of the subject property.
So on the Rick Finch, again, so on this, I know we've had a bunch of discussion about the impact of water, so I've got a couple points on this. One is the variance request is merely a recognition that this is a property that was in existence, a parcel that was in existence before the Viewshed ordinance was passed in January 2007. And as such, when we get down below, if you looked at the rest in the code that we had we must grant the variance if it was in existence before, and if the parcel hadn't been changed and some other requirements, which according to the application, this parcel meets those tests. So as far as the well, I mean, concerns granted by one commenter regarding the well and a concern that this may affect their well. There is also evidence and opinions that, this is part of the major aquifer, which is been dropping over years, and that, the addition of one or two exempt wells, probably has very de minimis effect. And, we have no documentation that this will have the impacts that the concerned citizens have raised. So and besides that, it's been stated that, the water is not our purview, that is the Department of Ecology. So, that said, my answer to B is yes.
Brian Davies and I will also vote yes to B.
Michael Cochran also votes yes. Letter C, that the variance is not required solely due to actions by the applicant which prevent direct compliance with use standards applicable to the subject property.
Rick Finch, yes.
Brian Davies, yes.
Michael Cochran, yes. D, the variance is not required simply for economic benefit constituting a grant of special privilege to the subject property.
Rick Finch, yes.
Brian Davies, yes.
Michael Cochran, yes. Staff recommendations. Unless information becomes available at the hearing that contradicts the finding of facts or information received to date, and the board agrees to the application meets the above criteria, it would be consistent for the board to approve this variance request. So then do we vote on that?
Motion to amend, yes.
I will entertain a motion.
Rick Finch moves to approve the variance.
I will second. Brian Davies will second that motion.
Having been moved and seconded, we'll move on to vote. Rick Finch,
Yes.
Brian Davies,
Yes.
and Michael Cochran also votes yes. That appears to be the end of our.
That's it, that's all we have tonight, yes.
Good job, Mike.
Thank you.
Yes. Thank you, gentlemen. I don't think we've got anything in the near future for you. You get a break now for that.
Now that you said
Okay,
that.
well,
Thanks, guys.
Okay, guys.
Thank you.
Yeah. Bye-bye.
As a landowner, I understand your concern. But as far as I read that, there's not enough evidence to prove injurious to you. Not saying that it can't happen.
Mr. Thompson, there's actually precedence, because there's a field next to our house that was also, there was a conflict because the neighbor wanted to put another residence there. But due to there's a natural stream running through there, you have, the police, southward of the Police River, right behind our property. I mean, for geological reasons, it was not.
I'm not sure what you're talking about.
Mr. Den Duff,
I know we can't duck this, but I don't remember this incident.
there's a field right next to us, and they wanted to put a residence there.
I don't recollect that. What year was that?
That was, within the last week?
I don't recollect that at all. We'd have to come through our office, and I have no memory of
Okay,
him
well,
applying
if you
for
don't
that.
remember it still, there is precedence.
Well,
And you guys, you can certainly the code and state law any that you want to.
We have made a decision, sir, and we're gonna have to disagree to disagree.
Okay.
That's it. The law is on our side, the RCW.
No, it's not.
Well, please read the RCW, because
I will,
apparently you
I will.
don't know about it. But you didn't respond to it when.
I didn't see that.
Well,
I got a letter from Mark Stewart, that was it.
I will send you the email that was sent to you, and I'll have a date stamp.
Okay.
Yeah.
Do that, please.
Okay, I will. Thank you. Yeah, right. I noticed, well, our roads guy, well, it's kind of close to the right way.
Yes, I just wanted. Our job is to.
Yeah, he knows that too. But just a heads up for you, you might want to protect that.
Yeah.
Because we're
All
all.
this stuff there.
How's it going? Good, how are you?
We have very little report, should never not do well.
Well, it's not our.
So you want to protect that well, and don't want to coach any further. All right.
Yeah, or that's, yeah, like the water's taken, that's not, and we're not here to.
We would have.
But as far as his complaint about the one part that says in the injury, again, it would be concerned, but he has no proof of it, he has nothing, no paperwork, nothing stating that this is gonna cause this problem, this property.
Of what someone.
Yeah, I mean,
So given,
Pisses me off, that's interest, right?
yeah,
You know,
well,
that's kind of what I'm talking about.
the neighbor driving by is right in the field next to you, it risks your yard, but,
You make people sign a legal form every time they build a house. Or do a little house, that they will not take no action regarding the farm.
good,
That's funny.
yeah. You bet.
Way to be a trooper.
It's difficult, and I get both sides of the deal here, but I also, in one of those, I'd like to have some say over my property, but I don't have any say over my neighbor's property. And